Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun, enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, my friends. Happy Friday. It is 10:10 at 10 o'clock. 10:10. Today's the 10:10 portal, so I don't know what that means exactly, but it's supposed to be good. I don't know. Everyone needs some help through the 10:10 portal? Let me pull you through. Well, in a move that should surprise no one, the Commonwealth of Massachusetts has opposed the appellate filing of Kelsey Fitzsimmons to review her bail de novo. And the Commonwealth wants Kelsey to stay in jail. Are you surprised? Are you shocked? I'm not. Something else is going on in Essex County too. In Haverhill, Scobuffs. And I want to talk about that a little bit first, because I want you to keep in mind that we may be seeing, I don't know, a pattern of conduct that is anti-female police officer in Essex County. I don't know. Just thought, just thinking maybe. Could be. So for those of you who don't know about Francis Gigliotti, 43-year-old Francis Gigliotti died while in police custody back in, was it in July? I don't know all the details to this, so I'm just kind of looking at the details now because somebody brought this to my attention yesterday. And based on what happened to Francis Gigliotti, I think that's how you pronounce it. 7 Haverhill police officers were put on paid leave. One of them, her name is Caitlin Tully, died unexpectedly. I've received information she may have taken her own life. I can't confirm that. It has not been reported anywhere. It has also been reported that the chief of police of Haverhill did not give any of those officers or any officers any sort of mental health assistance after this incident. This guy, the Haverhill police chief, resigned yesterday. Haverhill police chief Robert Pistone. It's nuts. It's Essex County, just like Kelsey Fitzsimmons. And you know what else is interesting? Tim Breedle represents the family of Francis Gigliotti. The medical examiner in that case has ruled his death a homicide. And it just, I don't know, makes my spidey senses go up a little bit. We don't know if she's related to Detective Tully. I don't think so. I do know that in her obituary, she is the niece of a Brian Tully of York, Maine, but I don't think it's the same Brian Tully. I haven't been able to confirm that, and so I'm not going to spread misinformation, and so I don't know. Hold on one sec. And so when we heard that insane hearing the other day, in which Tim Bradle was like completely dressed down because the phone system couldn't accommodate all the people that wanted to listen to Kelsey's case. And the way he spoke to Tim Bradle when he was telling him, "Where are you? Get down here." And then apparently Tim Bradle had the receipts that the clerk had said it was supposed to be a phone conference. And then the judge toned it down a little. That was Judge Dreckler in Essex Superior. And I don't know. I don't know if it has anything to do with Tim Bradle also representing the family of a man whose death may or may not have been caused by one or more Haverhill police officers. I don't know. Is there a connection? I don't know. Tell me what you think. It's insane. I just want to pull this up. And also, thank you, Mike B. from the 413, who just sent me an article from Boston 25. Caitlin Tully's sister gave an interview. And it has now been confirmed that Caitlin Tully was giving Francis Gigliotti CPR when he passed. Let's just take a look at the latest piece on Boston 25 that just came out. When was this morning? I'm going to move this. Hold, please. Let's take a look. I don't know. You know how we like to connect the dots here. And so sometimes we connect the dots in real time as we think of things together. It's like a big think tank here. Here we go.
Police chief is on leave following multiple controversies in the city. Boston 25 News reporter Ellie Murillo is on scene outside police headquarters with a story you will only see on Boston 25.
Well, Boston 25 obtained a letter reportedly written by families of Haverhill police officers heavily criticizing the chief for the handling of recent controversies that included the death of a man in police custody and the unexpected passing of police officer Caitlin Tully. For the first time and only on Boston 25, I spoke to her sister, and she's calling for transparency.
My sister...
The unexpected passing of Haverhill police officer Caitlin Tully has rocked the community. For the first time, her sister Amanda is speaking out. She tells me the morning of Caitlin's passing, she contacted Haverhill police for support, but says her conversation with Chief Pistone was disappointing.
It took him 3 hours to call me back, and his words to me were empty. He has not called my father, our father, or our mother to express his condolences at all.
The department has been the center of controversy. Back in July, it was reported that 43-year-old Francis Gigliotti died in police custody. It's still unclear if the 7 officers involved who were placed on paid leave will face any charges. Amanda tells me Caitlin tried to save Gigliotti's life by administering CPR. Her unexpected passing now also raising concern. Law enforcement and security expert Todd McGee tells me it's unclear what the department's next move could be.
There could be a scenario where this is just a private matter and the chief is taking time off for himself to attend to personal issues, but more on the public view, if there is a sense of scrutiny based on the direction of the department.
I tried contacting Haverhill Police and the union with questions like how the department is handling concerns, but also for more context on the decision for a leave of absence. I haven't heard back.
My sister cared about people. She loved everybody equally.
Flowers and candles now sit outside of police headquarters here. Amanda tells me that she cannot thank the community enough for their outpour of support. In Haverhill, I'm Eli Murillo for your local station, Boston 25 News.
Let me
It's
know
coming.
what you
Winter
think.
will
Oops,
descend.
stop. Stop. Here's a letter that was posted in the Haverhill Police Patrolmen's Association. And it really, really like blasted the police chief, Pistone. And it's horrific. Haverhill police deserve better from their chief. Both LPD and HPD have suffered losses this year, and this is no way to lead a department. This is a letter from the families of the Haverhill Police Department officers. Chief Pistone, you hold the titles of chief only because politics handed you the title. Titles can be given, respect must be earned, and you have not earned it. Real leaders show three things: experience, humility, and courage. Experience. Chief, you lack experience. You cannot lead men and women through battles you've never fought. Humility. Your insecurity governs your actions. You retaliate, silence, and punish those you should support. Courage. In every crisis, your first instinct is to protect your careers, not your officers. Even now, in the shadow of tragedy, your behavior exposes your motives. Every action since Officer Tully's death has been transparent in its desperation to preserve your own power. You have not stood before your officers at roll call, not spoken to them in their grief, not asked how they are enduring. You calculate how to save face while those you command drown in grief. That blindness, that self-absorption has become your legacy. The death of Officer Tully shook this department to its core. That you cannot even comprehend the depth of this wound reveals how unfit you are to lead. When you fail officers, you fail their families too. Spouses carry the weight of your pettiness and retaliation. Children absorb the tension you create. Parents watch their sons and daughters crushed under your pride. Every time you punish out of ego, the weight lands on the whole household. You have no just broken trust. You have broken families. You have not just broken trust, I imagine that should say. You stand in public about, quote, mental health, but it's a show. Your words are theater. Behind closed doors, you govern through intimidation and ego. You reward those who flatter you and punish anyone who speaks the truth. Officers learn quickly that being open only leads to being targeted, so they go silent. Silence becomes survival, and silence in this profession kills. That is not leadership. It is cowardice dressed in authority. History will remember you, but not as you wish. It will remember you as a warning, an example of what happens when politics elevates the insecure and untested. You will share the company of leaders who mistook fear for respect, who mistook control for loyalty. From Captain Sobel to every petty tyrant who rose on politics and fell in disgrace, or Sobel, you will take your place among them. Look it up. This past week, as Haverhill PD families honored Officer Tully, one truth became undeniable. You are not wanted, not in our homes, not at our tables. We admire Officer Tully's family for excluding you, like he was told not to come to her funeral. Be clear, you are not welcome at the funerals of our fallen. This is not the will of a single family, but of many. Your condolences are hollow, your presence an insult. You are not a leader. You are a burden that others must endure. You are the rot that weakens from within, and you will be remembered not for what you built, but for what you destroyed. The officers of Haverhill PD may be bound by rank and silence, but we, their families, are not. And so we reject you, not quietly, not partially, but fully and forever. Yeah. Okay. She knows. She knows what? What is with your? First of all, you're spamming the chat. Okay. Second of all, how many times did you see the gorgeous new attorney the O'Keefe family hired? Is that really like, I'm going to interrupt my stream? Like, give me a break. I think it's a troll. Bye. All caps. And so we reject you, not quietly, not partially, but fully and forever. We write this anonymously, not out of fear for ourselves, but to protect the officers we love from the retaliation that has become your hallmark. Let it be known there are hundreds of us, and if the public wishes to hear from us, we will step forward together and unafraid. The families of the Haverhill PD officers. And then, that's very powerful, right? This is to their police chief, and then he resigned. He resigned yesterday. Check this out. Where's that article? Hang on. Let's take a look at that. This is WCVB. But they're going to make me sit through a commercial first. So I will do that. I will do the Lord's work for you. Just hold tight for a second.
When a bit, this is breaking tonight. Haverhill's embattled police chief is off the job during a turbulent time for the department.
Chief Robert Pistone has announced his retirement. That's effective immediately. This comes hours after he was formally placed on administrative leave. The department has been under scrutiny since the July death of Francis Gigliotti, who was acting erratically and died after a struggle with officers. Gigliotti's death is considered a homicide. The DA is looking into it. The police union also blasted the chief's leadership after the sudden death of Caitlin Tully last month. Tully's father tells the Eagle Tribune that she was one of the officers placed on leave after Gigliotti's death. How she died is not been officially announced. Deputy Chief Stephen Doherty is taking over as interim police.
So there you go. Same county. I just thought it was worth pointing out before we dig deeper into that case, because we have not covered that case yet at all. It has also been released that Caitlin was performing CPR on Francis Gigliotti when he passed, or trying to, with 6 other officers on top of him, kind of, I guess. I haven't seen the video. It's, I heard it's horrific. All right. So now let's cover the opposition that the Commonwealth filed for the appeal of Kelsey Fitzsimmons' bail conditions. Remember, they filed an appeal for a de novo review of Kelsey's bail conditions to the one-panel SJC a couple days ago. And, well, when was that filed? Hold on, it's in the show notes. I can't remember the exact date right now. It was October 2nd. Hold on, let me just get the dates right. And this is dated yesterday. But the original appeal was filed by Tim Bradle on October 2nd. Here we go. Commonwealth's opposition to defendant's petition pursuant to General Law 211. The defendant, Kelsey Fitzsimmons, brings this petition for relief from an order of the Superior Court finding her dangerous and detaining her prior to trial, pursuant to General Law 276-58A. The defendant was indicted on August 25th, 2025 for 1 count of assault with a dangerous weapon. Although there is no indication that the defendant was intoxicated when she pointed her gun at a fellow police officer who was at her home serving a restraining order. And remember, these are the facts according to the Commonwealth. The Commonwealth demonstrated that alcohol fueled the precipitating violence in this case and had been a persistent issue for the defendant. Recognizing the dangers inherent in the intersection of alcohol abuse and mental health issues, the Superior Court Judge, Judge McCarthy, I've been told it's pronounced Nyman, N-E-Y-M-A-N, fashioned reasonable terms of release, including the condition of submission to a SCRAM device that would deter the defendant from consuming alcohol. Footnote 2 says SCRAM stands for Secure Continual Remote Alcohol Monitoring. A SCRAM device is a portable breath test that connects to the internet and on a scheduled basis has the client submit a volume of air to determine whether or not there are alcohol molecules present. This handheld wireless device uses face recognition software and operates remotely. Despite having obtained her release from custody, within 48 hours, the defendant was back before the court reporting that she was unable to abide by the SCRAM condition. Therefore, the court reasonably concluded that the only way to assure the safety of the community was to place the defendant in custody. This is wild to me. It's 24 pages long. And already you can see the tone, right? Despite having obtained her release from custody, within 48 hours, the defendant was back before the court. As if what? How dare she? She was lucky enough to get released. How dare she come back within 48 hours after being shot in the chest, spending 53 days in the hospital, undergoing 6 surgeries, having, I don't know, collapsed lung, lacerated liver, a couple of broken ribs. How dare she? She's lucky that we let her out. And this is the Commonwealth. And this is what I find so wild. It would be so easy for the Commonwealth to just say, and in the interest of fairness, we understand the devastating injuries that Kelsey Fitzsimmons, police officer Kelsey Fitzsimmons, sustained after being shot by one of our own. And so therefore, we have no problem if the court recommends or orders Kelsey to just go do urine testing for alcohol. We don't have a problem with that. But no, they're going to fight it tooth and nail. And based on their, I don't know, their demeanor in court, I thought maybe, they would, do the right thing. But they're evil, says Miss 808. Yes, these are the same prosecutors. Yes, exactly. These are the same prosecutors that raised no concerns during the hearing. You're absolutely right, Sheree. Hold on. And here's the procedural history. According to the Commonwealth, a complaint issued on July 3rd of 2025 charging the defendant with assault with intent to murder and 2 counts of assault with a dangerous weapon. The defendant was arraigned on August 7th, 2025, from her hospital bed, which they don't mention here, and after a hearing was ordered held pursuant to General Law 276-58A. The defendant appealed the determination of dangerousness to Superior Court, and on August 14th of 2025, again, they're calling her Judge McCarthy. They're not putting the Nyman in there, and we know she's got a hyphenated last name. On August 14th, the court conducted an evidentiary hearing. One day later, Judge McCarthy issued a decision upholding the finding of dangerousness and the conclusion that there were no conditions of release that could safely permit the defendant's release. Notably, the court found that it, quote, has not been presented with a satisfactory release plan. On August 18th, 2025, the defendant filed a renewed Superior Court bail appeal with a comprehensive release plan for reconsideration, which the court denied on August 25th of 2025. Footnote 3. The Commonwealth recounts the history of the case starting in the district court to highlight the familiarity Judge McCarthy had with the case even prior to the Superior Court dangerousness hearing. That same day, the defendant was indicted for assault with a dangerous weapon. The grand jury having returned a no bill on the proposed indictment charging armed assault with intent to murder. So remember, they took it to the grand jury. The grand jury did not indict on the attempted murder charge. They only indicted on assault with a dangerous weapon. The defendant was arraigned in the Commonwealth, which means to me, because a good prosecutor can get a grand jury to indict a ham sandwich. It's a famous quote from Chief Judge of New York, Saul Wackler. The grand jury didn't buy it. The grand jury didn't buy that Kelsey attempted to murder Noonan, the fellow police officer who shot her in the chest. And it's a pretty low bar in front of a grand jury. The defendant was arraigned and the Commonwealth filed another motion for detention pursuant to 276-58A. A lengthy hearing was held on August 28th, 2025, after which the court found the defendant dangerous, but concluded that she could be released with conditions, including GPS monitoring with home confinement, except for medical and legal appointments with 48 hours notice to probation. and no use of alcohol with monitoring by a SCRAM device. The defendant's release was stayed pending a satisfactory home visit by probation. So remember that when this hearing was held on August 28th, mainstream media was reporting that Kelsey was going to be released that day to the custody of her mother and stepfather. But that's not what happened. When probation returned an unsatisfactory result, the court held another hearing on November 8th, 2025, at which point the issue was resolved and the defendant was released. Before the November 8th hearing ended, wait, not November 8th. I'm sorry. November 8th, 2025 hasn't even happened yet. Today's October 10th, 2025. That hearing was on September 8th. The papers are wrong. Does anybody proofread anything in the Commonwealth? And again, they say it twice. Before the November 8th hearing ended. It's not. It was September. We know because we were there. Before the September 8th hearing ended, the defendant requested that the GPS conditions be lifted the following day to allow her to undergo a medical procedure. However, the defendant submitted no evidence in support of her motion, and the motion was denied. Okay, again, I'm going to point out the tone. How dare she? How dare she ask to go in for surgery the day after her release? She was released, remember, that was a Monday. She had a surgery on her liver scheduled for Tuesday. Tim Bradle said, Your Honor, she's got surgery scheduled for tomorrow, and I don't think any doctor is going to do a surgery with an ankle monitor on. So would it be okay if she has her surgery tomorrow and then we come in to probation right after she gets out of the hospital and they can put the GPS monitor on then? And the judge was like, yeah, no. And so Kelsey's surgery was canceled. That would have been, I think, her 7th surgery. 2 days later, how dare she? We have an emoji for that. The defendant filed an emergency motion for immediate relief from SCRAM order, but this says scam order, which is exactly what it is. It's a scam order. Well, thank you for pointing that out, Commonwealth. Emergency motion for immediate relief from scam order. Again, a second set of eyes on something that you draft is always a great idea, because a lot of times you can't pick up your own errors, and you need a second set of eyes to do that. But apparently they've got so many eyes, or not enough eyes. That's why I also feel like we're in Gilead a lot of the time, right? Anybody a Handmaid's Tale fan? Remember the eyes always watching the handmaids and everyone? Praise be. So 2 days later, the defendant filed an emergency motion for immediate relief from scam order, supported by affidavits from the defendant and her mother, and with an accompanying email from the probation department. The court held a hearing on September 11th of 2025, right? So now we're going back in time, where a probation officer testified about the SCRAM procedure and the defendant's apparent difficulty breathing deeply. At the conclusion of the hearing, the court removed the SCRAM requirement because she did not want to, quote, torture the defendant, and remanded her to custody. Well, I mean, I'm just going to point out the obvious here. Number one, she was not in violation of her conditions. The probation officer testified to that. He was not just a probation officer. He was actually the assistant chief. Said that he witnessed her pain personally, and that urine testing was an option, and that he didn't have a problem with it, and that she was able to complete the testing. It just was painful for her. She was not in violation. She would not have been violated. He would not have reported it to the court that it was a violation. And this was the defendant and her counsel's idea to come in and ask for alternative testing, which any other judge on the planet would have allowed. And in fact, the urine testing would have been random, which is what the judge said she wanted. And if you guys were here with me the day that we listened to the recording of the the court's hearing, it was horrific. I've never heard anything like it. And at the end, when she does send Kelsey back to jail, you can hear Kelsey crying, and I can't unhear it. Her fund is pinned in the chat. If anybody feels generous today and they have any extra $5 to give, every dollar helps. Legal expenses are mounting. Medical costs are mounting. Household expenses are mounting. Because despite the fact that she's incarcerated, she owns a home that Justin is trying to take away from her, by the way, the father of her child. Which is more torturous, do you think, for Kelsey? Going back to jail or blowing into the machine? So when the Commonwealth says to the world, the court removed the scram requirement because she did not want to torture, in quotes, the defendant and remanded her to custody. Are you offended by that? I'm offended. I'm personally offended by that. Because when Tim Bradle brought up in court that it was cruel and unusual punishment for her to have to blow into this thing because of her disability and her medical condition, every time he mentioned anything having to do with the Constitution, Judge McCarthy Naaman, Kathleen, said, "Oh, it is not my intention to torture her. Oh, you think it's cruel and unusual? Oh, you think it's a violation of her constitutional rights? Oh." It's where your constitutional rights go to die, like it or not. Massachusetts. Before the court could issue its 5-page written order later that day, the defendant filed a motion to reconsider. Again, how dare she? The court denied the motion to reconsider in an 8-page decision on September 16th, 2026. The defendant filed the incident petition without the evidence submissions from the various evidentiary hearings, the court's written findings, or an available transcript pursuant to General Law 211, Section 3, late in the day on October 3rd, 2025, and filed a supplemental exhibit on Monday, October 6th of 2025. The parties were in court for a pretrial hearing on October 7th, 2025, and the next court date is November 25th, 2025 for scheduling of a trial date. Yeah, that was the hearing on October 7th that we listened to by phone, and that was Judge Dreckler. And I don't know if he's taken this case over. I don't know why Judge McCarthy Naaman was not there, because she's fully familiar with this case. I don't know if it's been taken away from her or if it is just a function of the way these judges seem to rotate in and out of all of these courtrooms in Massachusetts. I'm not really quite sure. Statement of facts and before Judge McCarthy. Oh, and that judge also, Dreckler, was like, "When do you want to try this case? Let's try it next week. Let's try it next week. There's a lot of public interest in this case. I got all these people in my courtroom. Where are you, Bradle? Get down here. It's tying up our phone lines. We've been delayed all morning because so many people are interested in this case." Yeah, they are. The world is watching. The world is watching you, Essex County, Salem. But again, how dare they? How dare you pay attention to what we're doing in Essex County? They don't like it. They wanted to try the case next week. There's been no discovery yet. It's wild. Footnote 4 says the facts set forth here are detailed in the police report that was part of the evidence submitted during the dangerousness hearing. Contrary to the defendant's claim, the facts of the underlying allegation are hotly contested. At approximately 6 p.m. on June 30th, 2025, Lieutenant Sean Daly, Officer Patrick Noonan, and Officer Timothy Houston of the North Andover Police Department responded to 125, Phillipsburg Road to serve the defendant with a restraining order. The defendant, give me 2 seconds to just redact part of this. Yeah, they did try to push the case so fast that it was bizarre. And here's another thing that I want to know, because we just read about Caitlin Tully, Officer Caitlin Tully, and how she wasn't given any mental health treatment after what happened with Francis Gigliotti. Do you remember that we talked about how Kelsey responded to that horrific scene about a year prior with Officer Noonan, in which a new mother had taken her infant's life and her own life? Did they ever receive any grief counseling or any treatment after that? I don't know. I have questions. Two seconds. Okay. Couple thank yous here. Thank you to Deborah Gelsey for gifting 5 memberships, and to the 5 who were generously gifted. Welcome. So on 6 p.m. on June 30th, 2025, Lieutenant Sean Daly, Officer Patrick Noonan, and Officer Timothy Houston of the North Andover Police Department responded to Kelsey's address to serve the defendant with a restraining order. The defendant, a North Andover police officer, resided at that address with her fiance, Justice Alian, and their 4-month-old infant. Earlier that day, Alian had sought and was granted an abuse prevention order out of Essex Probate and Family Court. Right, that was ex parte. Just a heads up. Anybody who blocks a mod is an automatic block. Do I need to change the settings? Hold on one second. What's the name? I'll find it, Scott. Don't worry about it. Oh, no, we got it. You got it. Oh, okay, you got it. Thanks. Earlier that day, Alian had sought and was granted an abuse prevention order out of Essex Probate and Family Court. And remember, that was ex parte. He went in there by himself, and it was based on his word only. Alian alleged that the defendant physically assaulted him over the previous weekend. I'm going to remind everyone that was the Bachelor and Bachelorette weekend in Maine. And that he was in fear of her and for the safety of his child. He stated that the defendant had assaulted him in the past and feared that the defendant would hurt herself and the child if he were to leave. Along with serving the order, the officers intended to remove the defendant's firearms from the residence and transfer custody of the child to Alian. So, great way to get custody if you want it. Just go into court by yourself, say that whatever you want, and it's horrific. It's horrific. Hang on. The officers informed the defendant about the restraining order, advised her that she was thus required to relinquish her what? Relinquish her what? Relinquish her and give Alian the baby. It probably is supposed to be firearms, but it's not written there. The defendant told the officers that her firearms were locked in a safe in the basement. Approximately 10 minutes after the officers arrived at the residence, they called Alian to gather his belongings and take custody of the infant. So many things are wrong with what they did here that it would take me all day to even point them out. Okay, wait a second. So you're going to walk into a breastfeeding mother's house. She's breastfeeding her baby who's 4 months old on the couch in a house that she owns, that her fiance was allowed to live in with her prior to their wedding. They were supposed to be married right around now, early October. You're her coworkers. You're all men. You show up with a restraining order to take her baby away. And then within 10 minutes, you call the guy who just got the restraining order against her, who happens to be the father of her baby, who just betrayed her, to come to the house to take the baby and get his stuff? You don't bring a mental health professional. Kelsey had been out on leave for postpartum depression. They knew that. She had just gotten her guns back. She was just ready to go back to work. And within 10 minutes, you're calling that guy to come to the house? Can anybody see how she might have seen everything that she had worked for her entire young life being taken away from her in that moment? In anticipation of Aaliyah taking the baby, the defendant began to gather items, clothing, diapers, bottles from around the house. Officers Houston and Noonan escorted her between the rooms. After gathering bottles and diapers on the first floor, the officers escorted the defendant to the second floor so that she could gather baby clothes. I don't think that's true. I think it was only one who went upstairs with her. But here they're going to say officers. Maybe they'll call it a scrivener's error. We'll see. While they were on the second floor, Aaliyah and the defendant's mother arrived at the house. Well, who called Kelsey's mother? I bet it wasn't the cops. They just called Justin. When the defendant heard Aaliyah, she asked Officer Houston to keep him away from her. Wouldn't you? To maintain order, Officer Houston left the defendant and Officer Noonan on the second floor and went to monitor Aaliyah as he gathered belongings in the basement. So Noonan was alone with Kelsey. No body cams. They don't use body cams in North Andover. And if the guns were supposed to be in the basement in the safe, and Houston went down there, Houston, we have a problem. Why didn't you check to see if the guns were in the safe? You think Justin knew the combination to the safe? And didn't the police report also say that Justin was in the garage? But okay, let's go on. Lieutenant Daly remained on the first floor with the defendant's mother, Elaine, and Officer Houston. Minutes later, he heard Officer Noonan on the second floor yell, "Kelsey, don't do it. Kelsey, don't do it," followed by 2 gunshots. He ran upstairs and rendered first aid to the defendant and requested an ambulance to the scene. Footnote 5. I have questions about why Lieutenant Daly was the one to render aid instead of Noonan, the guy who shot her, who was there already. Footnote number 5 says Officer Houston also heard Officer Noonan scream, "Kelsey," followed by 2 gunshots. Thank you, Thorne, PhD, because that's what I was going to say too. The officer saying, "Kelsey, don't do it," seems more consistent with trying to stop her from hurting herself. If she pointed the gun at him, what do you think he would have yelled? I don't know, drop your weapon? I wonder if Kelsey has ring cams. And I wonder if there's footage. I have so many questions. Lieutenant Daly observed a firearm where the defendant was lying and moved it to the bed out of the reach of the defendant. I guess Daly was the one who rendered aid. Officer Noonan explained that he was briefly alone with the defendant on the small second floor. Well, briefly? Define briefly. The defendant was kneeling on the floor in her bedroom while folding laundry for the baby. While standing in the doorway, Officer Noonan observed the defendant face him, lunge behind the door, and reappear, pointing a firearm directly at him. The defendant pulled the trigger and he heard a click, but no round fired. Was it loaded? The defendant began to stand up. Hold on. As Officer Noonan pulled his firearm out of its holster. As the defendant attempted to rack her firearm to chamber a round, Officer Noonan gave several commands, including drop the gun and don't do it. Nobody heard the drop the gun part. Believing that she was trying to kill him, Officer Noonan fired once as the defendant continued trying to chamber a round. Officer Noonan fired a second round, striking the defendant. Where did the first round go? Can't make this up. Where did the first round go? Was it a warning shot? Did he miss? He couldn't have been that far away from her because it's a small room, they said, right? Superior Court 58A hearing. At the 58A hearing in Superior Court on August 28th, 2025, the Commonwealth submitted the state police report detailing the above facts. The Commonwealth also submitted an affidavit filed in support of a 209A restraining order filed in the probate court by Elian on June 30th of 2025. The affidavit outlined that the defendant was heavily intoxicated and physical with others during an incident in Maine on or about June 28th, 2025, which was described as the defendant's bachelorette party. As the 209A order was issued from the probate court, a judge found that there was a substantial likelihood of immediate danger or abuse to Elian. The materials submitted by the Commonwealth also included written statements made by Elian and other people who were present during the incident in Maine on June 28th and the incident on June 30th. I wonder if those people were all family members of Justin. I have questions. Through these statements, witnesses described the defendant as intoxicated, drinking heavily, and engaging in aggressive behavior towards numerous individuals during the June 28th incident. Imagine being drunk at a bachelorette party. That's so insane. The statements also reference prior similar behavior by the defendant. The defendant argued that she should not be found dangerous and moved that she be admitted to personal recognizance or reasonable bail under Section 57 of the bail statute. Defense counsel submitted reports from Dr. Nisevic, a doctor on the psychiatry service at Massachusetts General Hospital, and Dr. Zeisel, a licensed forensic psychologist. Based on the materials submitted by defense counsel, Dr. Nisevic opined that the defendant no longer met the Section 12 criteria, being a harm to herself or others, and is appropriate for outpatient care once medical, stabilized, and discharged. Through their motion, defense counsel requested that the court issue appropriate orders in the interest of justice set forth above. Footnote 6, which says, however, as Judge McCarthy noted, the defense did not submit any documentation regarding the defendant's medical condition as part of the dangerousness hearing. Not a single medical record or affidavit from a treating physician were submitted in either the district court dangerousness hearing nor the superior court hearing. As part of their piecemeal litigation, defense counsel filed a medical notice to the court on September 5th, 2025, which was simply a filing by defense counsel and was impounded by the court. Well, I'm sorry, but isn't the fact that she was in the hospital for 53 days in the court record? What part of she got shot in the chest does nobody seem to understand? She was arraigned in her hospital bed, and guess what else? There is no door in her bedroom. So when we come back here and it says Noonan observed the defendant face him, lunge behind the door, and reappear, pointing a firearm directly at him. The wild part of this is that there is no door on her bedroom. They said that she said that the guns were in the basement. They said she told them that the guns were in the basement. Oh, the boyfriend's not living in her house now. The boyfriend has filed a petition in the probate court proceeding saying that because her house is now on the market, because she probably has to sell it to pay her legal fees, that's my guess, he would like all of the proceeds of the house to go to him for future child support for their child when he doesn't even have full custody and custody has not been determined and he's absolutely insane. But whatever proceeds there are from the house up to, I think he asked for something like $200,000, right? He wants those proceeds now. And I've been saying this since the beginning, and I say this in every case, follow the money. He wants 17 years of child support up front. That's what he wants. Yep. It was over 211,000. Yep. And the maximum sentence on this, thank you, Suze, is 5 years. Is he just in it for the money? Justin? After argument from the Commonwealth and defense, the judge found that the defendant was a danger based on the above alleged facts, her history of mental illness, and the defendant's out-of-state record, including public intoxication and disruption. Okay. Kelsey's out-of-state record, including public intoxication and disruption, was like when she was a kid or, I don't know, 21 or something, and it was in another state. It's from 2018. It's a misdemeanor. She pled to it. And as we all know, she had to go through intensive background checks to become not only a corrections officer, but also a North Andover police officer. So this is a little bit, I don't know. They make it seem like it's much more than it is. Public intoxication and disruption, a misdemeanor charge that she pled to that was out of state, maybe when she was in college or something. Her history of mental illness. Oh, are you referring to the postpartum depression that she suffered that she went out on leave for? Reaching, right? Per the Young Jerks, Justin won't let Kelsey's parents see the baby. That's horrific. Spunky Nana. If true. And why would he be allowed to do that? I don't know. I think she was 21 when that happened, out of state somewhere, when she was in college. And did the judge, wait, I don't remember, did the judge consider that? I guess the judge did consider that. Dr. Zeisel rings a bell to me too, and I can't remember. I think Dr. Zeisel also examined Lindsay Clancy. Right. That he did. So Dr. Paul Zeisel is the same guy who initially evaluated Lindsay Clancy and will be testifying at Lindsay Clancy's trial per Kevin Reddington. That's why the name sounded familiar to me. I couldn't remember what case it was. He might, did he testify in Turk too? He might have. Yeah, makes sense. So after argument from the Commonwealth and defense, the judge found that the defendant was a danger based on the above alleged facts, her history of mental illness, and the defendant's out-of-state record, including public intoxication and disruption, but that there were conditions of release that would provide the necessary protection. GPS home confinement, residing with her mother and stepfather, compliance with mental health treatment, and abstaining from alcohol with scram testing. However, the defendant's release was stayed pending a satisfactory home review by probation. And let's go to the chat for a second before we move on with the papers. One second. New members, Just Irish, welcome. Crazy Cat Lady said, I'd always wanted to visit Massachusetts, but not anymore. And Priscilla Thompson, thanks for being here for 5 months. Says Massachusetts sounds scary. We're starting to call it Massachusetts. Mike B from the 413, I think both these Essex cases need Rosemary Scapiccio, even if she just sits in the courtroom gallery for hearings and vigorously takes notes. Well, Martha Coakley is on this case. But it doesn't seem to matter to any of the judges involved in this, Mike. Just Irish's motion to allow a scam order emoji. It's a lot of letters. I don't know how well that would play on a little tiny logo or emoji. Thank you for being with me for 13 months. Kelly Applegate's here for 5 months. Commonwealth of Massachusetts is so crooked. It reminds me of a commercial for Peyronie's disease. Unreal. That's funny. Happy Friday, cupcakes. I cannot believe we are back here dealing with another insane case, says Mr. D Head. Thanks for your 5. Letteros by Bettero, 21 months. An OG says, my head has rolled into the abyss. I'm speechless. Karen says, Tim Bradel represents Gigliotti's family as well. Yeah, I mentioned that before. Thanks, Karen. Tons of Fun 911. How was he allowed to take custody? They weren't married. I assume the child is not legitimized. Well, he's on the birth certificate. They were engaged. And that's what the probate court decided, at least temporarily. Tons of Fun says the baby should be with her family, in my opinion. And Josh says Noonan's report doesn't add up with what the lieutenant heard. Are you surprised? The rest of that footnote, which I didn't realize, continued on the other page. And this was about when we're talking about the medical records. The defendant finally filed a letter signed by a medical doctor on September 15th, 2025, well after the defendant had been remanded to custody and after the defendant filed the motion to reconsider. The one-page letter summarized the defendant's injuries and supported the claim that deep breathing may be painful, but did not indicate that deep breathing would hinder the healing process. Oh. So apparently the Commonwealth doesn't give a rat's ass if it's painful for you. If it's not hindering her healing process, so what? No big deal. We don't need to just agree to let her pee in a cup. Contrast defendant's petition at page 2, the defendant reported that she could not use the device without great pain and aggravating the healing of her broken ribs. I'm again going to point out to you how difficult it is to get an affidavit or a letter or any medical documentation signed by a surgeon because you know what? They're busy doing surgery. After reviewing the CARI reports, CARI reports of the residents of the defendant's proposed place of release, the court ordered a further hearing. On September 8th, 2025, the court released the defendant according to previously ordered conditions, footnote 7. Defense counsel characterizes this judicial oversight of the location of the defendant's release as, quote, micromanaging the release plan. The Commonwealth suggests that this is laudable attention to detail and is understandable where a superior court judge makes a determination to release a potentially violent and mentally unstable defendant into the community. But before the hearing even ended, the defendant sought an order to relieve her of the GPS device for the following day to attend a medical procedure. Yeah, it was a surgery on her liver. However, the defendant did not submit any evidence that the defendant could not wear a GPS device during the procedure. The court denied the request. 2 days later, on September 10th, 2025, the defendant filed an emergency motion for immediate relief from, oh, now it says scram order. The defendant claimed she was, quote, unable to do the testing without experiencing severe abdominal pain and dizziness, and it impairs healing of her broken ribs and punctured lung. Because the breathing into the scram device was, quote, physically impossible, the defendant could not comply with this order. The defense moved that it be vacated. The motion was unsupported by any medical evidence, but attached an affidavit from the defendant and her mother and an email from the Assistant Chief Probation Officer, Jeff January. On September 11th, 2025, the court held a hearing and made abundantly clear its perspective on alcohol testing. When defense counsel framed the issue as, quote, a simple adjustment of terms, the court disagreed. Oh, yeah, she did. I don't see it that way. I'm telling you, it's not a simple adjustment. One of the reasons she was released and one of the reasons to ensure the safety of the community was for her to be alcohol free. If she cannot do that or will not do that, that changes everything. And her tone was far meaner than mine. And you know, because you were here. Defense counsel argued that although the defendant could pass the test, it was only with, quote, difficulty. At the court's discretion, police PO January was sworn, and he described the defendant's prior day's performance on the scram tests and informed the court that the tests were conducted at scheduled times. Footnote 8. Judge McCarthy indicated that she was surprised that the testing was not random and that the defendant was apprised of a testing schedule. Defense counsel argued that although the defendant could pass the test, it was only with difficulty. Oh, we just read that. Okay, we were here. He also observed, this is January, also observed that the defendant appeared to be in genuine pain during the setup process, and for that reason did not believe that failures to complete scheduled tests were willful violations of probation. The court also accepted the defendant's scram history as evidence. The Commonwealth presented no evidence, but reiterated how important that the Commonwealth's belief is in light of the court releasing the defendant, that testing be done. After confirming that the defense had nothing further to present, the court heard argument from defense counsel. He reiterated that the test was only possible with significant pain and dizziness and having to recover for several hours. He argued that there's other ways to do this. If the court wishes to have her tested for alcohol, lack of alcohol, that's completely fine with the defense, but just the means that's employed is kind of a torture device for her. Well, the judge did not want to hear that. Cruel and unusual punishment and a potential Eighth Amendment violation. And that's where things went off the rails. However, the defense did not offer any specific alternative methods of testing. It was in the freaking email that was attached to the papers. The judge would barely let anybody speak. She kept cutting him off. She was mean. She was mean to PO January when he testified. And let me know if you think the Commonwealth is being kind of jerky here. The court took a recess before issuing a decision. And here's her quote. I have reviewed everything again that's been submitted to me, and I will state for the record that Fitzsimmons has moved twice in a 3-day period to amend her conditions of release. On neither occasion has she submitted any medical evidence to support her claims. The imposition of conditions is the court's order after careful consideration of the evidence to fashion the least restrictive conditions that will reasonably assure the appearance of the defendant and the safety of all other persons in the community pursuant to General Law 276, Section 58A. Just days ago, the court concluded that the condition of remaining alcohol-free and submitting to scram monitoring was necessary to ensure the safety of the community. After a thorough review of all of the arguments and submissions by the Commonwealth and Fitzsimmons, yeah, exactly, Karen. That's exactly what she did. That conclusion remains unchanged regardless of Fitzsimmons' claimed physical limitations, right? She took a break. She typed up this whole decision, or had somebody type it up, and came out and just read it from the bench. After a thorough review of all the arguments and submissions by the Commonwealth and Fitzsimmons, that conclusion remains unchanged regardless of Fitzsimmons' claimed physical limitations. Based on an affidavit submitted by Fitzsimmons' mother, the testimony of Assistant Chief Probation Officer Jeff January about his observations of Fitzsimmons' apparent pain during the scram installation, and the representations of Fitzsimmons' counsel that it would be cruel and unusual punishment and torture to continue to require Fitzsimmons to comply with the conditions with the condition of being monitored by Scram, the court concludes that Fitzsimmons cannot abide by the condition of being monitored by Scram. Without this condition, which ensures that she does not consume any alcohol, the court cannot assure the safety of Officer Noonan and all other persons in the community. Accordingly, the court's prior order of release is vacated, and Fitzsimmons is ordered to be held without bail pursuant to Massachusetts General Law 276, 58A, and a written order will follow. I mean, it was already drafted. Footnote 9, which says, although the defendant disparages Judge McCarthy in his petition and attempts to characterize her behavior as injudicious and short-tempered, the transcript reveals that she presented the defendant with every opportunity to present evidence and make argument. Oh, wow. What a tattletale. Pointing out that they think that Bradel disparaged the judge. What a tattletale. I'll read that again, thanks to. Although the defendant disparages Judge McCarthy in his petition and attempts to, well, first of all, the defendant is a she. So if you're talking about counsel, you could say defendant's counsel, but the defendant herself is a she. Although the defendant disparages Judge McCarthy in his petition and attempts to characterize her behavior as injudicious and short-tempered, the transcript reveals that she presented the defendant with every opportunity to present evidence and make argument. Well, the transcript is very different from the recording. Oh, what a tale we tattle. You can read the transcript in any tone you want, but you really need to listen to the recording to get a full picture of the judge's behavior. We did. I ordered it. We got it. We listened to it. Hold on. After a recess, she issued her ruling from the bench and concluded the hearing. It was defense counsel who interrupted the judge, yelled to the bench after the hearing was concluded, and had to be chastised by a court officer for swearing. Well, is that the end of the footnote? For swearing. Okay, there's no period there. Did he swear? We didn't hear it on the recording because they cut the recording off. Judge McCarthy issued a written order later that afternoon, but before it was docketed, the defendant filed a motion to reconsider. Okay. She read her decision from the bench. Okay. She read her decision from the bench. It was clear what her order was. So who cares if it was docketed or not? In a zealous representation of his client, should Tim Bradel have gone home, waited a couple of days for the court to get around to scanning the order into the docket? You know how long it takes in Massachusetts for things to get docketed or scanned. But before it was docketed, the defendant filed a motion to reconsider, asking the court to release the defendant and order alcohol urine screens at a private facility. The defendant supported the motion to reconsider with an attached email from P.O. January from September 10th, 2025, in which he had responded that the only alternative to scram testing was urine screens at a probation vendor. Judge McCarthy denied the motion to reconsider, finding that there is nothing in the motion that was not known to the defendant or her counsel when this matter was last before the court on September 11th, 2025. There has been no change in circumstances or newly discovered information that would warrant revising the court's decision pursuant to 276-58A4 or Massachusetts Rule of Criminal Procedure 13A5. The court reasonably concluded that the defendant's, quote, failure to transparently provide information related to her ability and willingness to abide by the conditions imposed despite 3 lengthy hearings is a manipulation of the court's efforts to fashion the least restrictive conditions of release. Wow. I don't know. Could this ADA kiss the court's butt anymore? Are you kidding? Judge McCarthy noted that because they were silent during this hearing, they were like, yeah, no, we got nothing. We got nothing. They never consented. They never said we have no problem with it, but they didn't oppose it. Judge McCarthy noted that the defendant's deliberate decision not to present the alternative urine testing through a private vendor through testimony of the probation officer, quote, at the hearing on September 11th, the court gave the parties ample opportunity to present their arguments. It was in the email. It was in the email that the judge said she wasn't going to give no weight to because it was hearsay. And then it was the ADA who said, oh, Your Honor, well, he's present in the courtroom. And then she let him testify. It's insane. Mr. January was present and testified under oath. For some reason, rather than bringing the alternative testing to the court's attention and inquiring about it with Mr. January during his testimony before the court, defense counsel at that time sought only an order completely relieving the defendant of her condition of release, requiring her to submit to scram monitoring, footnote 10. That doesn't sound right to me. We listened to it. 10, Judge McCarthy also noted that the proposed alternative, which was not supported by testimony from the probation department, would significantly alter the home confinement condition. Yeah, because she would have to leave the house to go to the place to pee in the cup. But I don't know. Shouldn't the court be aware of the alternative ways to test for alcohol in Massachusetts? Or is this the first time in her long and storied career that she has ever had to order alcohol monitoring for a defendant? On October 3rd, 2025, the defendant petitioned this court pursuant to 211 Section 3, but failed to provide the court with the documents necessary to prevent this court with a complete picture of the lengthy 58A litigation. Argument. Roman 1, a petition pursuant to 211 Section 3 is the appropriate avenue for relief in this case. Gaslighted, she says. Mass-lighting, it is mass-lighting. The Commonwealth agrees that the application is properly before this court. Filing a petition pursuant to 211 Section 3 is the proper means for seeking relief from bail determinations in the Superior Court. Footnote 10 says, Judge McCarthy also noted that the proposed alternative, oh, we read that already. Okay, I just didn't highlight it, so I forgot. Roman 2, the defendant's actions in pointing a loaded firearm at a fellow police officer and pulling the trigger, coupled with an admitted history of mental health illness and alcohol abuse, history of alcohol abuse, because she was arrested for public intoxication when she was 21 years old in another state. Yeah, that's a long history of alcohol abuse. Talk about misstating the facts and misleading the court, and pled out to a misdemeanor charge. Amply supported the lower court's findings as to her dangerousness and the need for detention. Robin says Kelsey can't receive a fair trial in this court, period. Cammie says they should know, for crying out loud. She's a judge. And David Reese said the judge asked all the questions of the PO. Kim is a North Andover resident and she's embarrassed to be one. She says, this is crazy. I'm embarrassed to be a North Andover resident after seeing how our officers handled this entire situation. Letteros by Bettero. Alcohol abuse. These people are evil. Lies and more lies. No integrity any longer. Shady Norfolk County DA says nobody knows that is what actually happened. There's no body cam footage. Grace Base is just so mad. Kelly Cope doesn't know how these people sleep at night. Wet My Whistle wants to know if Noonan is on administrative leave. That's a great question. Does anybody know if Noonan is on administrative leave? I don't remember reading that anywhere. DBK in Maine says the Commonwealth is more concerned with covering itself than protecting its citizens. This is just one more example of their BS. Oh, Billy Bush, my friend Billy Bush, who's been on who's been on my show and I've been on his show. His brother just announced that he's running for governor of Maine. Oh, Noonan's not out on leave. He's back to work. Jonathan Bush, I think his name is. He's running for governor of Maine. I don't really know anything about him other than that, other than Billy Bush announced it yesterday. Moving on. Sue says, didn't the judge order random testing? She did. No, I don't think it was in the order, but she thought that she did, and that's what she says she wanted. If so, why scram? They let a guy off on $10,000 bail for breaking a cop's nose. And Regina wants to know why Noonan's not in jail. Yes, he has 7 children. He's the father of 7. Mr. Jonathan Bush. Thank you, Weekend at Bevies. Happy Annie says that Noonan got rewards after this. And Kylie says, from one corrupt state to another, I'm making this my business because it could be any of us. I don't know. I'm getting the theme of, pinning it on the girl. Pinning it on the girl. Because we watched Judge Krupp's behavior day before yesterday on the motion to search Karen Reed's phones that they've had in their possession since January of 2024. They seized those phones in January 2024, 2 phones from Karen Reed, 2 additional cell phones to try and get her for conspiring to commit witnesses with Aidan Carney. Apparently they took the phones, but they never searched the phones. And it's been 20 months, which under the case law seems to be an unreasonable period of time. And not to mention that I believe Judge Cannoni's already ordered the release of those cell phones. So then Cosgrove went in and made a motion because they just can't let the girl get away scot-free. They got to pin something on the girl. A lot of people have been pointing out that Aidan Carney has been saying, well, they're not going to find anything on her phones because they would have it on my phones or because the communications between us. But they're not just going to look at communications between Aidan and Karen. They're going to look at everything involving Karen. Who knows what she may have told somebody else about something. They will twist whatever they find to make it fit their narrative of trying to pin something on the girl. And I fully believe that. And I think Krupp's going to allow it. I really do. And it's outrageous. And you should be outraged. But Karen Reed is their white whale. And they're not going to let it go. Because if they let Karen Reed go, a lot of people higher up and perhaps throughout the entire state, who knows how high it goes up into government and how spread out it is. And, the Canton Mafia, I don't know. But they're not going to let this go. In fact, they're doing more of an investigation into Karen Reed's phones than they did into the murder of John O'Keefe, because the people or person who murdered John O'Keefe is still walking among you over there in somewhere, Norfolk County. Where's the investigation into that? It's outrageous. Oh, no, it wasn't Brian Albert that was in court that day. It was Chris Albert. So, Sarah, I'm just going to just delete that so it doesn't get out there as misinformation. But Chris Albert was at federal court the same day Jessica Leslie was there to get sentenced. And Jessica Leslie sat on the federal grand jury, right? She did not sit on the state grand jury for Karen Reed, because I heard some twitty the other day on a live stream talking about how Jessica Leslie was on the state grand jury. She was on the federal grand jury. That's why she heard the CDL scandal too. So a lot of misinformation out there. Right. Have they looked into the Ford Edge at 34 Fairview yet? No. 3 a.m.? No. Dee says, I live in Norfolk County. My ex-husband worked in Norfolk County as a deputy sheriff. I know the corruption in the good old boys club, and it makes me very nervous. Right. So I've been hearing about the corruption in Norfolk County for decades, because I too have friends and family from Norfolk County for decades, like since the 80s. Glamasu says, had she been on the state grand jury, she would not be in federal court. Well, somebody needs to alert Roberta Glass that she was on a federal grand jury, not a state grand jury. Moving on. The 80s, good old days. Thank you, Leave the Drama at the Door, for gifting a membership. I appreciate you so much. And Leaving Drama at the Door, Leave Drama at the Door says, I'm keeping my opinion silent for now, but I sense a cover-up. Free Kelsey Fitzsimmons. Thank you. Thank you for your 5. Irish Mima says, the biggest error in the paperwork is that it is in the interest of justice. Should read, it is in the oh, wow, this is so good. I got to take it back to 1. The biggest error in the paperwork is that it is in the interest of justice. Should read, it is in the interest of Justin. Well done. Well done, Irish Mima. You are correct in saying that there's something flew by fast, but it was a great comment. So hold on, yeah. Lexi Lynn. So her alcohol arrest so long ago wasn't an issue for her to become a sworn officer. Nope. She was a corrections officer, and she became a police officer. So no, wasn't an issue. Thank you, Scott Messerschmidt, for being here today, and also for saying, please click the pinned comment to show your support of Kelsey. Thank you very much. Carly with a K says, Mel, I love your stream. Thank you so much. Truly beyond words for shining a light on this. I live in Massachusetts near Kelsey, and I know firsthand how awful these people are. I can't stop thinking about Kelsey. If you can't stop thinking about Kelsey, write her a letter. You can write her a letter. All of the extensive instructions to do so are in the show notes underneath this video. It's got her address. It's got all the instructions on what you need to send and what you're not allowed to send. She is getting your letters and cards, and they are making her very happy. And I saw somebody post yesterday that they got a response from Kelsey and that they were so happy to get a response. Karen never had to scram. Nope. Karen didn't have any alcohol monitoring, and her charges involved alcohol, manslaughter while under the influence of alcohol, vehicular manslaughter. Karen never had alcohol monitoring. Nope. Nope. Okay, back to Roman 2. Second point. The defendant's actions in pointing a loaded firearm at a fellow police officer and pulling the trigger, coupled with an admitted history of mental health illness and alcohol abuse. She didn't admit a history of alcohol abuse anywhere. Amply supported the lower court's findings as to her dangerousness and the need for detention. Yeah, Kylie Cosmos. When you have one standard, why have one standard when you can have double? The government has a paramount interest in protecting its citizens, which is served by the pretrial detention regime. It's a regime, all right. Specifically, the dangerousness statute seeks systematically to identify those who may present a danger to society and to incapacitate them before that danger may be realized. Section 58A is a measure intended to protect the public from the violent acts of a dangerous individual. Pretrial detention is warranted if the judge finds, by clear and convincing evidence, that no conditions of release will reasonably assure the safety of any other person or the community. The lower court's decision to detain an individual pursuant to 58A is reviewed by this court for an abuse of discretion or error of law. An abuse of discretion occurs when a judge made a clear error of judgment in weighing the factors relevant to the decision such that the decision falls outside the range of reasonable alternatives. A, the finding of dangerousness. Here, no error of law or abuse of discretion has been established. As an initial matter, Judge McCarthy, again, why are they not calling her McCarthy Nyman? Does anybody at MassDad, do you have any idea why? Isn't that her judicial name? McCarthy-Nyman? Reasonably concluded that the defendant was a danger on August 28th of 2025. With respect to the facts of the charged offense, from the outset, the defendant lied about the location of her guns, an apparent attempt to lull the officers into a false sense of security. She then pointed a loaded firearm at a fellow police officer, pulled the trigger, and repeatedly attempted to load more bullets into the weapon when the first shot did not fire. Repeatedly? Didn't he only say she tried to rack it once? But, you know, facts don't really matter. Facts don't matter. Come on. The nature of the offense, combined with the defendant's recent history of violence against the father of her child and threats to the safety of her own child. Again, misstatement of facts. Because in the beginning of their papers, they did not say that she threatened the safety of her child, but that Justin feared that she would hurt the baby. So, you know, just keep twisting the words to best support your position because the facts don't matter. Big Old Dog says, because the Nyman is the connection back to Justin's family, I bet. As Judge McCarthy noted, a probate court judge found that there was a substantial likelihood of immediate danger or abuse to the child's father. Oh, yeah. And Kelsey wasn't heard during that proceeding. Just Justin. Furthermore, Judge McCarthy recognized that the defendant had a history of mental illness. Alean wrote that she had been recently sectioned by Lawrence General Hospital, and the defense acknowledged a history of postpartum depression and suicidality. She wasn't actually sectioned. She was, I believe, unless I'm conflating my cases, that they tried to section her, but they didn't, that it didn't work, that she was released within a few hours, just like they tried to do to Karen Reed. Remember? They tried to section Karen Reed too, but she was released within a couple of hours. But he wrote that in his papers because it sounded better for him. And also because his parents know how to maybe work the system, maybe. To get people involuntarily committed. We looked at an article that told us about that, about what his parents do and the organization that they're involved in, and how they've said in articles that they know how they teach people how to get loved ones involuntarily committed, I think, if I recall correctly, right? Who are, who have addiction issues and other things. Among factors the court may consider under 58A are the nature and seriousness of the danger posed to any person or the community that would result from the person's release and the defendant's history of mental illness. Given these circumstances, Judge McCarthy properly found by clear and convincing evidence that no conditions of release will reasonably assure the safety of any other person or the community. And here's a case citing Mendoza. Constitutional attack rejected as to 58A detention, predicated on defendant's history of threats in the context of evidence of his psychiatric hospitalizations, drug dependency, and suicidality. B, the scram conditions of the release. Rather than hold the defendant in custody, the court sought to fashion the least restrictive conditions of release that would reasonably assure her appearance and the safety of all other persons in the community as required by 276, Section 58A. I don't know. I'm just spitballing with you here, just tossing it out there. Don't you think urine testing would be the least restrictive condition as opposed to, the cruel and unusual punishment of a woman in her medical condition having to blow into that machine for however long she's got to blow for how long she has to blow for? Most importantly here, the court ordered the defendant to submit to scram monitoring. Despite the defendant's cavalier approach to removal of the condition and her persistent view that alcohol was not part of the incident in any way, Judge McCarthy justifiably found that monitoring the defendant for alcohol use with a scram device was critical to the court's decision to release her on conditions. The precipitating events over the weekend of June 28, 2025 that caused Elian to obtain a restraining order were fueled by alcohol. He reported that the defendant was heavily intoxicated, at her bachelorette party. Again, his opinion. And that she refused his request to stop drinking. The defendant's childhood friend corroborated that the defendant had been drinking on June 28th and that her actions that night were erratic and violent. The friend further stated that the defendant had struggled with mental health issues, aggression, and alcohol abuse previously. All right, so let's take some hearsay from her friend, her alleged friend. She might want to get new friends. Finally, the defendant even has out-of-state criminal charges that reflect issues with alcohol. Right, from 2018 when she was 21, disturbing the peace. Unbelievable. Oh, I don't know if that's true, Jen and Toxic, but that would might track, right? If true. Footnote 11. The Commonwealth could not locate a copy of the defendant's CARI/Roman 3 in the court file, but the record reflects that Judge McCarthy had a copy during the hearing. The copy included in the record appendix at page 69 to 70 fairly represents what was before the court on August 28th, 2025. Where alcohol is so clearly intertwined, really, is it that clear to you? Because it's not that clear to me. Justin, the guy who wants custody of their child and wants the proceeds from Kelsey's house and wants full custody and wants child support for the next 18 to 21 years, and an alleged friend and a misdemeanor plea that she took out of state when she was 21. I'm sorry, what? That's makes it so clearly intertwined with the defendant's ability to control her behavior. Okay. The court's insistence on scram monitoring was eminently reasonable. And this is coming from the Commonwealth, who took really no position during the hearing. Right. Norman Corey says, so if all this was true, why did the fireman want to marry her? He sounds like he could be nuts. Right. And then girl Ryan says, wait, we can take negative hearsay from a friend, but not a probation officer. Right. Exactly. What? Is it me? Am I crazy? No, you're being gaslit. You're being gaslit. C, the motion to remove the scram conditions. The defendant's motion to relieve her from the scram requirement triggered reconsideration by the court, not revocation pursuant to 58B, as claimed by the defendant. Footnote 12. In fact, Judge McCarthy specifically rendered her decision pursuant to 58A4. Section 58A4 specifically permits reconsideration of a prior detention order where there has been a material change in circumstances. Quote, The hearing may be reopened by the judge at any time before trial if the judge finds that 1, information exists that was not known at the time of the hearing, or that there has been a change in circumstances, and 2, that such information or change in circumstances has a material bearing on the issue of whether there are conditions of release that will reasonably assure the safety of the community. Okay, I'm going to address those one by one. Number 1, information exists that was not known at the time of the hearing. Number 1, they did not know at the time of the hearing how difficult it would be for Kelsey to complete that test, which required her to be in substantial pain for hours after the test was taken. They did not know that at the time. She had not tested it. She had not tested the test. And when they figured it out within 48 hours, as they point out, they were back in court asking for urine testing. And number 2, that such information or change in circumstances has a material bearing on the issue of whether there are conditions of release that will reasonably assure the safety of the community. You want her to have alcohol testing? There are other ways to do it. The urine testing at the facility, or Massachusetts could spend some money and get one of the Scram ankle monitors that also tests for alcohol every 30 minutes. But they don't have those in Massachusetts, but they could get one. Maybe they could take all the money that they had earmarked for the body cams, the $100 and something thousand, I think, that they didn't use for body cams. And maybe they could spend, I don't know how much that one ankle monitor would cost. Somebody would need to call Scram and find out. Yeah, and somebody's pointing out too, wasn't Justin arrested in New Hampshire for possession of weed or something when he was like 19? We're not considering that though, right? Could there be addiction issues in Justin's family because his parents were involved in that, and still are in that organization that helps families of addicts and how to get them put into drug treatment and sectioned? I don't know. Somebody posted like the website of this thing the other day, of this organization, and it says that every single person except for 2 involved in this organization had a family with a family history of addiction issues. Hold, please. So that's how I would address those 2 points. On September 11th, 2025, after learning about the intense pain caused by the process of the Scram testing, Judge McCarthy became justifiably concerned because she did not intend the condition to be punitive. That's laughable. That is laughable. However, ordering the defendant to remain alcohol-free and monitoring her for alcohol use with Scram device was critical to the court's decision. Good, get the one that can also test for alcohol. Given the evidence supporting the imposition of the Scram device in the first place, as noted above, Judge McCarthy was well within her discretion to conclude that she could not assure the safety of the community if the defendant's sobriety was not reliably monitored. Well, I don't know. This would be a great opportunity and great marketing and a great, I don't know, PR for Scram. If you're out there listening, Scram Corporation, I don't know the name of your company. I think it is called Scram. Could you donate one of your ankle monitors that tests for alcohol to Kelsey Fitzsimmons after what she's been through? You know, in the interest of justice and all, maybe you could donate one of these monitors to the Essex County Probation Department for special use by Kelsey Fitzsimmons, who, in my opinion, is being unreasonably held in jail, who had her infant ripped from her bosom based on the sworn handwritten statement of the guy who wants the baby and the house that's only in her name. Yeah, McCorkle, elected judges have the same issue because elected judges get the nomination through a lot of political favors. So, I mean, these judges in Massachusetts are appointed. Given the evidence supporting imposition of the Scram device in the first place, as noted above, Judge McCarthy was well within her discretion to conclude that she could not assure the safety of the community if the defendant's sobriety was not reliably monitored. The defendant's claims that Judge McCarthy should be aware of alternative testing options is without evidence in the record. I don't know. Can we take judicial notice of the fact that she's a judge? Does she handle criminal cases? Has she ever ordered? I mean, come on. This is just so laughable that is hard to explain. Moreover, Judge McCarthy's concern that the defendant manipulated the process is justifiable. Defense counsel failed to raise any concerns regarding the defendant's ability to breathe deeply in 2 prior hearings and persistently failed to introduce medical evidence to support her claims. Well, if the judge doesn't know that urine testing exists, how is Tim Bradel supposed to know that what is required in this blow device is going to cause his client pain? You can't use it as a shield and a sword, my friends. But that's exactly what they're trying to do here. Additionally, there is no explanation for defense counsel's failure to question P.O. January about his email from the night before regarding urine testing, or to mention the possibility to the court when given ample opportunity, other than it was a reasoned tactical decision by a seasoned defense attorney seeking to release the defendant from alcohol testing entirely. No, I disagree. Anybody who's not a trial lawyer is not going to understand this, but you can be so spun out by the way that a judge is behaving because it's so outside the realm of possibility and outside the realm of anything that you could have predicted walking into this hearing, that he could have just been completely spun by the judge's behavior. And as someone pointed out, wasn't it the judge asking all the questions of January? And wasn't that email already in the record? And didn't she keep cutting Bradel off? And didn't she cut him off at the end when he asked the judge, can I? No. He said several times, Bradel did in that recording. He said several times, she's perfectly willing to submit to alcohol monitoring. That's not a problem at all. It's just the method that is painful for her. Unbelievable. And then they cited footnote 13, which says, and in any event, Judge McCarthy appeared disinclined to consider the urine testing option where it would require release from her home confinement. Moreover, the testing seems an unreliable means of confirming sobriety when the individual is informed in the morning that they will not be tested that day. I can't remember what the record said with regard to that. Whether there was ever testing, there would ever not be testing in one day. I don't remember that. There would be no disincentive not to drink that day when they are aware that they will not be subject to testing. I'm still waiting for them to address the ADA argument. I'm still waiting for them to address the court violating the Americans with Disabilities Act. And we're at the conclusion, so they don't even touch it. And then they cite a case, Commonwealth v. Pagan. A motion to suppress is not a dry run or a dress rehearsal to come back once an adverse ruling is obtained to try and do it all over again. Oh yeah, because we love to try and come back and do it all over again with Judge McCarthy Nyman. In sum, Judge McCarthy acted prudently and deliberately in considering the Commonwealth's request for detention. She considered the evidence presented and made multiple supportable oral and written findings, resorting to detention as a last resort. The defendant has not demonstrated that she made an error of law or abused her discretion. Yeah, they did. The Americans with Disabilities Act. Are we being gaslit again? Footnote 14. Nothing prevents the defendant from requesting relief at a time when the defendant is healed and able to perform the scram test without pain, or if a new testing alternative becomes available. Hello, Scram. Can you donate that ankle monitor now by end of day? Thank you. Judges have considerable discretion to permit a pretrial motion that has been heard and denied to be renewed. Conclusion, for the foregoing reasons, this court should deny the defendant's petition. XOXO, Marina Moriarty, ADA for the Eastern District. Right out of Salem, Massachusetts, home of the witch trials. Yeah. This is the Commonwealth response to the SJC. Yes. If you're just tuning in, Where's the opposition to the argument about the Americans with Disabilities Act? Where's that? Did I miss that? No, because I went through 24 pages of it. And I didn't see it. Did you see it, Cardi B?
Hello.
Hello.
Did I miss it? And she's got a lacerated liver, but she's gonna be drinking. Right. And Bradel did say, says Amy Adams, if there was no alternative, that she would continue with the scram. It's just painful. He said she would do it. He said she would. Wow. LawTube's most hated mod says the procedure for a urine test takes about 10 minutes minimum and can take a long time. Took me 7 hours once to be in the cup. It's not discussing about the Disability Act because they don't think she's disabled, but then they should put that in their papers though. I mean, you have to address the argument whether you agree with it or not. And if you disagree with it, then you got to say why, right? Outer Space. True Dead says, at this point, I'd expect the SJC to also back up the judge. None of these people have an ounce of morals or ethics. Back to the chat. Angel Moon says, how can you go from loving her to wanting to see her in jail because of postpartum depression? My head hurts for her. She must feel so broken and confused. Shame on him for hurting his child's mom. Yep. Yep. And he was fully supportive. And we've been through all of those articles and, you know, the North Andover Fire Department baby boom and how he's quoted in the article as saying after his baby was born, I can't wait to have another one. Freedom Ring says tattletale, more like brown noser and simp for trial judge. Thanks. I wasn't going to say it, but thank you, Freedom Ring, for your 5. Mindy says, what about the letter from the Mass General from her surgeon? Yeah, they talked about that briefly, Mindy. I think I'm a little bit behind in the super chats. Thank you. Fairy Raven says, judge's immunity needs to be abolished. Thank you, Fairy Raven, for being here from Ireland for 20 months. Bridget says, police officer January testified that the urine test could be done randomly up to 6 times a day. And the place was up the road from Kelsey's parents' house, if I'm remembering correctly. I don't remember if he testified to that or if it was in his email. Thank you, Brigitte, for your 10. Tennessee Jet is here. I'm sick. The families of Kelsey, Enrique, Justin Root, and police officer Tully. Well, let's not forget Francis Gigliotti. Police officer Tully, right? Caitlin Tully, not to be confused with Brian Tully. And anyone else need to hire a PI to investigate all the corrupted people. Is Cox over all of these? Well, he's Boston PD. Who was in the email of Michael Marcy? Those were all of the Stoughton court judges. That email was to all the Stoughton court judges. And that was Stoughton District Court. This is Essex Superior Court. But what the opposition that we just read is going to the SJC. Norman says, thanks for covering this, Melanie. No geofence done on Colin's phone to prove he was not there at 3 a.m. with his Ford Edge. If I was accused, I would have paid for that info myself to clear my name. Oh, great. That's a great point, Norman. Thanks for your 20. Becky says, just McCarthy now since Aiden nicknamed her Judge. Okay. Thank you for your 5. Laura said, you had me at Cardi B. Hello, you complete me. Thanks, Laura. Heartless Soul. How Massachusetts has treated John's death and how they're treating Kelsey. I don't think I'd want to be a law enforcement officer there. Yep. Under your scars. It's been for 2 months. Massachusetts spend the money you're wasting on body cams. Thank you for being here for 2 months. Rosie's Overruled says, in my opinion, this is not correct. Facts. Thanks, Rosie. There's always at least 3 sides to every story, right? Your side, my side, and the truth. Always. Kay Huber says, this is easy. The prosecutor was directed to write a supporting document by the judge. Thank you, Kay, for your 5. Angelique. Would it be an idea that the cupcakes mail the company to donate this gram? XOXO from the Netherlands. Free Kelsey. Corrupt BS. Thanks for tuning in from the Netherlands. I wouldn't suggest that you inundate them with your emails, but I don't know if they have a Twitter account. I don't play on Twitter, but some of you guys do. Kay Willis is a realtor, and she's been here for 11 months, and she says, I don't understand why judges have such power. Well, that's the system. Wide discretion. Kay Willis is a realtor, so if you want to get out of Massachusetts, she's south of Boston. She's your girl. Give her a call. I saw a flurry of emails come in about something that I think everyone is, I don't know if everyone's sending me the same thing, so hold on a second. Hold on a second. Thank you, sweet Caroline. All right. Thank you, sweet Caroline, for sending this to me because I have not seen this before. This is the Merrimack Valley Stringer, and this is dated June 30th of 2025, and this is based on radio transmissions. Let's take a look at this. It says all information in this report is based on direct on-scene observations and publicly available fire and EMS radio transmissions. In Massachusetts, such transmissions are classified as public records and are legally accessible under the Massachusetts Public Records Law. Details included are provided in the interest of public safety, transparency, and accurate incident reporting. Let's take a look. Thank you. Merrimack Valley Stringer. This is North Andover Fire, and this is the EMS transmissions from June 30th of 2025. See what it says. Emergency crews from North Andover Fire Department and Boston Med Flight responded to a critical medical emergency involving an off-duty female North Andover police officer with gunshot wound, GSW, on Monday evening, June 30th of 2025. Wasn't that interesting that North Andover Fire Department, where Justin is a firefighter, responded also? And Med Flight, she was airlifted out of there. At approximately 6:22 p.m., North Andover Fire and EMS were dispatched to Phillips Brooks Road after an off-duty North Andover police officer was shot by another North Andover police officer following an armed confrontation. Initial 911 calls indicated the victim had sustained a serious injury. North Andover police were serving a court order at a residence when an armed confrontation took place soon, which was followed by an off-duty female officer being shot. By 6:25 p.m., North Andover fire personnel had arrived on scene and immediately began life-saving measures. At 6:28 p.m., Engine 1 requested Boston Med Flight due to the severity of the injuries. First responders reported that the patient, a 28-year-old female North Andover police officer, had sustained a gunshot wound to the chest with an exit wound through the back. This makes my heart hurt. Advanced airway management was initiated and crews were beginning to, it says, breath for the patient on scene. At 6:30 p.m., North Andover Fire advised that a hot load would be required for the patient transfer at the landing zone, meaning the aircraft would remain running during the patient handoff to expedite transport. By 6:33 p.m., Ladder 1 was redirected to Lawrence Municipal Airport to assist with helicopter landing operations. Car 2 and Engine 1 arrived at the airport by 6:37 p.m. to prepare for transfer. At 6:43 p.m., North Andover Ambulance 1 began transporting the patient to Lawrence Airport after a blood transfusion in the field, arriving by 6:46 p.m. The handoff to Boston Med Flight was completed under critical care conditions. Boston Med Flight departed Lawrence Airport at 6:56 p.m. en route to Massachusetts General Hospital in Boston. The flight arrived at MGH at approximately 7:09 p.m. An additional North Andover police officer was also transported to the hospital for medical examination after the incident, as he was the one who shot the female officer. The identity of the victim has not been released at this time, pending family notification. Local and state authorities are actively investigating the circumstances surrounding the incident. North Andover Police and Essex County DA's office is actively investigating the incident. As of 10:30 p.m., it was an active crime scene with Massachusetts State Police, North Andover Police, and Essex County DA's office on the scene. Oh, the DA's office was on the scene? Does the DA's office usually come to the scene? I saw something go by that said she had an amazing medical team, and it was an RN who posted that. She does. She did. The fact that she lived is very, very lucky. Blood transfusion, a shot through and through. Airlifted. But according to the judge, there's no evidence to support that it would be impossible for her to blow into this thing. That was you, Kathy. Kathy says it's amazing that she survived. Right, and live without brain damage. Very lucky to be alive. Wags says, dispatch is my old language. I'm imagining this chaos. Yeah. No, I don't think Noonan went with her in the helicopter. I think that they said that they took him to the hospital too, but he was not airlifted. No, it just says an additional North Andover police officer was also transported to the hospital after this incident, as he was the one who shot her. Little Cupcake said, who did Kelsey harm ever? Miss Jessica MB says, I've seen in Afghanistan these shots, and it is very lucky. Derek Carney says, God sent her some angels, though. They look like cupcakes. H-Bag said, I've seen Marcy go to crime scenes before. Amy Adams says, the SJC has to see the injustice here. I don't know. I wonder how long it'll take to get a decision on this. Everyone remember to hit the thumbs up while we're here. Helps the algorithm. Yeah, they were going to get married in October. I think the wedding date was like October 4th. Yep, agree. Nasty Trumpet. Isn't it super important for an infant to be with her mom or his mom for their development? No one has said Kelsey was a risk to the baby. She can barely breathe. She's no danger to any adult. Well, Justin says so. Jennifer Bell says urine alcohol testing on random days would work because the analysis tests for alcohol metabolites that stay in the urine for several days. They should know this. The PO knows. Ugh. Thank you very much to Sweet Caroline for sending that, because now we're getting a picture of what exactly happened that night and how horrific her injuries were. Sarah, thank you for your Venmo. Actually, I misnamed her, but I'm not going to name her because she says, I worked for North Andover Police as a dispatcher. They were terrible people. Oh, this is interesting too. Thank you. Well, somebody just sent me a whole bunch of Facebook posts from the Alean family who seemed to love Kelsey at some point. So let's take a look at this. Thanks, Lauren. Until they didn't. No. Come on. Here's a post from by Lisa Alean. This is dated, what does it say? May 3rd, 2024. Congratulations, Kelsey. You have worked very long and hard to get here. You should be very proud of yourself. We loved celebrating with you. I think that says May 3rd of 2024. Here's one from June 2nd, also from Lisa. I guess that's Justin's sister. And this was posted on June 2nd. Kelsey's in the picture with the baby. By, again, Lisa Ali. And yesterday, the Newton Police Explorer Post 300 had a ceremony dedicating benches to my dad and his something, which I can't read. So was her dad with the Newton Police? Oh, Lisa is Justin's mom. Oh, okay. Justin's mom. So his grandfather maybe was with the Newton Police? Maybe, according to this post. Yesterday, the Newton Police Explorer Post 300 at a ceremony dedicating benches to my dad and his something that I can't continue reading because it got cut off. There's Kelsey all the way on the right. Oh, maybe his sister is his sister Ashley, because here's something from Ashley, November 10th, 2024. It says, "Do you think I'm adopted?" I'm guessing here that Ashley's the brunette. And here's Justin all the way on the right. Justin all the way on the right, next to Kelsey. The blonde in the middle, I think, is maybe Justin's other sister. And then this is Ashley who posted it. I'm not sure who this guy on the end is, but this was just on November 19th of 2024. And then the same post from from that same day by the same sister, Ashley. Also says, do you think I'm adopted? November 2024. Yeah, their wedding was supposed to be last weekend. So there's that. Lauren said, it's funny. They seem to love Kelsey. One of those posts was just from June 2nd. Funny how things can change so dramatically that by June 28th, Kelsey's a monster because maybe she got drunk at her bachelorette party, if you believe their story. Did anybody here not get drunk at their bachelorette party? So I don't know which sister was which, but thanks, Megan, for the docket entry on Karen Reed. I know I couldn't find that order either. I don't know if like docket number 732, there's just regarding Karen Reed's release of property, there's just a notation in the docket from July 30th that says Commonwealth's motion for permission to return physical evidence to defendant was allowed on July 31st, 2025. But I don't remember now. I think it was for all the phones, right? The original motion was for all of the phones, not just the phones seized in January 2022, right? So again, if there's already an order to release the phones, I don't know why Karen's new attorney didn't argue that in front of Judge Krupp. Your Honor, another judge has already ordered the release of these phones. Let's see how we talk about a lot of things at once here. Hold, please. Thank you, Kristen, for sending me this. Kristen, can you send me a link can you send me a legitimate link where this came from? Because it's right now it's a screenshot and I can't verify its authenticity. So I don't want to put this out there unless it's like really a House bill. And like, what's the status of it? So I don't really know. I can't verify this, Kristen, but thank you. It's a link there, but it takes me to like the formatting on this is all screwed up. So I just don't know if this is real. Hold on. HD 4311, hold on. I mean, all right. Well, this is interesting. Whatever happened with this bill? Okay, take a look at this. This looks like it's a government website. It's masslegislature.gov. There's a bill in the House to recall some judges, and I've been told that Judge Krupp is on this list. So let's take a look at this together. Because that's what we do. We get into rabbit holes and then we can't get out. Kristen just happened to come upon this because, like you and me, she fell into a rabbit hole. Check this out. Mass Dad, maybe you could take a look at this. This is malegislature.gov/bills. This is bill number HD 4311, an act to legislatives to recall and impeach the following Massachusetts state judges. Last history on this was that it was docketed in January of 2025 and that it was scheduled for the House Journal agenda. So I don't know if this has ever been heard. It's a people's petition, but it doesn't look like there's been any action on it. So this is a people's petition. It's HD 4311. I don't know if it's been considered or what the procedure is for a people's petition in Massachusetts, but here it is. People's petition to the legislatives to recall and impeach the following Massachusetts state judges for violation of our judicial rights, constitutional civil rights, and human rights. Note, this is just a partial list of names, but we will be adding to them more names as we received it from individuals. If you have names to add, please send it to us. We must have judicial accountability in Massachusetts. Yeah, the petitioner is a citizen. So I don't know if they've got standing. I don't know if this is something that is going to be actually addressed. Nunya says number 2, Bill Belichick. It says here, oh, how long is this? I mean, there's a lot of judges on the list, but let's see how many of them we recognize. I guess some angry citizen filed this. It says we must have judicial accountability in Massachusetts. Our constitutional republic is founded upon the idea that government is of the people, by the people, and for the people, not above the people. No one serving an elected or appointed office should be above this standard, including those in our judicial branch. Judicial performance evaluations should not be confidential and only reviewed by a small group of unelected judges. These performance evaluations must be public and available to the Governor's Council, the elected body responsible for vetting and appointing judges, and to elected members of the legislature serving on the Senate and House Judiciary Committees. This increased transparency on the conduct of lifetime appointed judges will provide greater insight into our judicial system. The Governor's Council should be able to conduct open, transparent, and public hearings reviewing judicial performances. No one should be above the law. The judges listed below have segregated our courthouses, practice unethical corruption, obstruction of justice, bias, prejudice, racism, discrimination, hate crime, inhumane tortures, abuse, and cruelty, and tainted our judicial system. They are not judges, but gangsters in black uniform. They have violated our judicial and constitutional rights. And then this person is calling for the recall and impeach the following judges. And we'll just scroll down here because it's a long list. See if we recognize any of the names. Number 14, Judge Peter B. Krupp. See if Judge Cannoni's on this list. It says Judge Erskine, but isn't she retired? If it's the same judge from Massachusetts. I mean, not Massachusetts, New Hampshire. Didn't she have something to do with Montgomery? Harmony Montgomery? Or she's been speaking out about Harmony Montgomery. Scrolling. See, there is a judge, another Judge McCarthy, Maura McCarthy, but it's weird, I think, that the Commonwealth referred to Judge McCarthy Nyman as just Judge McCarthy in their papers to the SJC. Well, the list isn't going on. We're up to 85. I don't know if this has anything to do, if this will even be heard, but thanks for sending it to me so we could take a look at it. I don't see Cannoni on this list. And this was filed January 2025, would have been after the first Karen Reed trial. Caroline says, what the hell happened to innocent until proven guilty? Well, It's still supposed to be there, but you know. Is she retired, Carol Erskine? If that's the same Erskine that they're talking about. Oh, Law Girls Not Attorneys podcast says that's Judge Mary Black is the probate judge on Kelsey's case. Thanks, girls. Nice to meet you guys at the Wilbur that night. I remember. Let's see. Judge. Let's see where she is on the list here. Mary Black, number 61. Law Girls Not Attorneys podcast. Thanks for coming in. Canoni's name is not on there. But again, that was filed by a resident. I don't know what, if any, effect that will have on anything. But thanks, Kristen, for finding that. Yeah, I posted this on my Instagram story. Lindsay Gattani posted last night on the cesspool of Twitter. Fun fact, Jen McCabe has several voodoo dolls of Karen Reed, Aidan Carney, and others sitting in a wicker bowl on a table in her dining room. That's sane. And then somebody wrote something like, are you serious? And then she wrote, as a heart attack. Wondering if she's got a voodoo doll of me. And other people who don't think that John O'Keefe was hit by a car. Wouldn't be surprising to me. Thoughts, questions, comments, concerns. I have a lot of concerns. Leanne says, hi, Melanie. New press release from acting Haverhill police chief. Sick over both these cases. I'm a Haverhill resident. Where can I find it? Hold on. It's not in my inbox. Haverhill police chief retires after being placed on leave. No confidence vote. I don't know where I can find it. Thanks for letting us know. I'm sure somebody will go look for it. Thank you, Leanne, for your 5. And I'm sorry that you live in Haverhill and that you're sick over this, but a lot of people are sick over it too. Husband sounds like a duck. Thank you for your 5, Mr. D-Head. And New Hampshire woman says, so if this had happened after they were married, he would have left her. So much for sickness and in health. Yep. Thank you, New Hampshire woman, for your 5. She 3PO says, police deny serial red rummer as 16th body pulled from bayous in 2025, 7 in a month, 5 in 5 days. Officials say it's just how homeless bury each other, no public concern. That is news to me. And so I don't know what state that's coming from. Are you like Louisiana? Thanks for your 10. The bayous. If you want to send me some articles on that, I'll take a look. My email's in the show notes below the video. Thanks for your 10. Ms. Holmes says, I was yelling at my laptop, Attorney Buzang, during his argument to not allow Karen's phones to be searched. He was like a limp noodle, in my opinion. And here's some breaking news that just broke at 5 minutes ago. 19 people missing after bomb factory explosion in Tennessee. 19 people are missing after a major explosion at a Tennessee bomb factory on Friday morning. The blast was reported just before 8 a.m. local time at the Accurate Energetic Systems plant at the Hickman-Humphreys County line west of Nashville. 19 employees were inside the building at the time, and everyone remains unaccounted for. Officials said the main concern at this time is the possibility of a secondary explosion. The Bureau of Alcohol, Tobacco, Firearms, and Explosives, the ATF, has been called to the scene. Oh, that's tragic. Yeah, there's a bomb factory, Sophie. Apparently there's a bomb factory. That's coming to you from the New York Post. Yeah, I'll show you. You like receipts? I'll show it to you. It came up on my phone, so now I got to find it on my computer. As of 5 minutes ago. Well, my browser has lost my connection to my thing, so I don't think I can put it up for you, but we'll see. Can you see it? All right. Oh, it's lost to the audio. I don't need the audio. Okay. It says 19 people missing after. I don't want this video. Go away. Go away. Hold on. I need reader mode. But I lost my cursor too. 19 people missing after a bomb factory explosion in Tennessee. At a Tennessee bomb factory. Yeah, that's what they're calling it. Robin said Karen needed Alessi to argue the nuance of the case law. I don't know. Judge Krupp sounded like he already made up his mind, didn't he? Sounded like he already made up his mind that the only thing that needed to be done was for Buzang to meet with Cosgrove to agree on the tainting protocol. That's what it sounded like to me. I don't think it need. There's no decisions in my inbox, so he did tell Buzang he could have some more time until like the 21st to submit some opposition to the tainting protocol, which he didn't even oppose. Like, you can't just expect that you're going to win by walking in there. You have to oppose everything in the motion. That's why it's so surprising to me that the Commonwealth did not even address the ADA argument in the papers to the SJC. Thank you, Ms. Holmes, for your super chat. And Under Your Scar says, retired Judge Erskine was on Young Jerks about Kelsey's case. She wrote a book about Harmony Montgomery's case. Profits go to kids and petitioning courts in the system. Thank you. Thoughts, questions, comments, concerns. His ruling will likely come out at at 4 or 5 o'clock today. I know, because she did say that he was going to have a chance to oppose it. And she was going to give him to the 21st to put him. He was going to give Karen's attorney until the 21st to put in more papers, right? Or was it that they had until the 21st to agree on the protocol? Because now I'm confused. I wonder if we'll hear from the SJC today. I wonder. I don't know. I don't know. She3PO says, apologies, Melanie. The Bayou bodies found in Houston, Texas. We'll email links. Also needing more coffee. Thank you. Thank you for another 10. I appreciate you. Lily Lime says, Bradel had to tell him what to say. It sounded like he came into court already deciding he'd allow it, says Dana Zuber, but he also thought that the phone had already been downloaded. He assumed that it had already been downloaded but not searched. But then Cosgrove was with the abada. We need the password. I don't think we could download it without the password. And just wild to me. He wanted to oppose the protocol. Yeah, but he should have done that in his papers, right? He should have already done that in his papers. Kylie says, how could Justin's family feel good about any of this? Are we just going off the idea that a baby doesn't need his mother? How do you live with yourselves, dude? Great point. Okay, so something coming up next week is the SJC arguments for Dennis Bateman, and we haven't gone over those briefs yet. If we have enough interest, we can go over the briefs and the arguments before Tuesday, and then we can watch the SJC arguments. That is a man who was convicted, I believe, in 2005 of taking the life of a girl named Brandy who worked at the Sunoco station. Wait, is it Dennis Bateman? Hold on. He's asking for a new trial. He's been in jail since, I think, 2005, 2007. Hold on. Lost everything. Okay. He's a Greenfield man convicted of killing Brandy Waryaz and her unborn child, right? She was 7 months pregnant. I started reading the briefs last night. I'm not done reading them yet. But apparently, the defense has an expert witness who's going to testify that the Commonwealth altered a bunch of the audio tapes of the defendant's statements, that they withheld evidence and withheld a witness's name. We're waiting for the SJC is allowed to rule on this de novo without oral argument. The one judge panel is allowed to do that. So that's what we're waiting for. But I think this is going to be an interesting case, and I think we should cover it. And I think I'll go. I'm not going to read the entire briefs to you. We're not going to read all the briefs, but I can bullet point the arguments before the SJC argument on Tuesday, and then we can watch it live because it's more examples of the Commonwealth hiding the ball, going back all the way to 2005. He was convicted in 2007. Yeah, and it's wild. I was reading the briefs, and there's a lot of like conflicting witness testimony. There's a third-party culprit that the police never looked at. It's like same old, same old. He's got evidence that he wasn't even in the area at the time that she was murdered at the Sunoco station, but she was his friend. So he knew Brandy, and he went there because his van was breaking down and he needed some change for gas or something. And she said, just go into my purse and get it. So he was there, but he wasn't there at the time that the Commonwealth says that he was killed. And then there's other witnesses who saw a different man there, a different black man there with very different features. This man was bald. And the witnesses say that the man that they saw had hair. And it's kind of wild, but I'm going to go over it and hopefully we can get to it before Tuesday and then watch the oral argument and see what happens with that. Jailhouse snitches who, may not have been so truthful and were promised things, and the things they were promised were not turned over, things like that. Jimmy from Lynn says the SJC single justice will release her by the end of next week, or they'll kick it back with instructions to release. No violation. They took her liberty. I agree with you. I don't know if that's what they're going to do. I have grave concerns. I have grave concerns about all of the things going on in Massachusetts that that we have seen happen in real time. HB Sunshine says, thanks for reading the papers today. Can you please share the name of your daughter's band again? I didn't say it was my daughter. It's Paris Ray and the Crush. You can find them on all streaming platforms. All right. Law Girl says, I want to know more about why Judge Mary Block was on that list. Well, it was a list that was just filed by a citizen. So, maybe this guy's got personal beef with all the judges on that list. I don't know. But do a little digging, Law Girls. Do a little digging. Kelly, I saw you've been spamming the chat with this like 5 or 6 times. So I'm going to pull it up. 1, 2, 3 times you've put this in here. How do you feel about the handling of Kyron Lacey case by officers and the prosecutor's office, especially with all the video witness statements coming out and now the AG is looking into it? I'm not familiar with the case, which is why I didn't highlight your comment, just to tell you that I'm not familiar with the case. If you'd like to send me any information about it, my email is always in the show notes below, but you were trying to get my attention with this comment, but I'm just here to tell you that I'm not familiar with it. So I can't feel any way about it until I know more about it. If you want to send me something, feel free and I'll take a look. Mitchell can't leave Massachusetts because his grave is paid for. Oh, Mitchell. Oh, Mitchell. You're funny. Yeah, I saw Karen Reed's family brought in a new lawyer from California. I don't have any thoughts on that because I haven't looked into her. I did see that you guys sent me that everyone's posting her picture all over the cesspool of Twitter as if her picture has anything to do with her credentials or her credibility or her skill set. I mean, I don't know. Her name is BB or BB Fell, based in San Diego. She filed a pro hoc vice application, which I believe was quickly granted. There's no reason why it shouldn't be. I wouldn't read too much into that other than they're going to need a lot more help. The O'Keefes. Did I say the O'Keefes? Sorry, not Karen's family. I'm sorry. The O'Keefe family. It's the O'Keefe family. The plaintiffs have hired another attorney to come in from California. Her name is BB Fell, B-I-B-I, Fell. She's beautiful. They're posting her picture all over the place. I don't know anything about her credentials or her background or her experience. They're going to need all the help they can get, though, if and when the judge allows 10 more defendants to come in. She parachuted in. She watched the criminal case, says Robin. Yes, she's been hired by the O'Keefes. She's on the plaintiff's team. I wouldn't read too much into that other than they don't get, I know it was the O'Keefes that did. Didn't I just correct myself 14 times? Yeah, Big Old Doug says we're shallow creatures. It's not Karen. Yeah, but Karen was wrong for bringing in California lawyers, right? Right. So I don't know anything. Right, exactly. You would think her credentials would be more important to post than her photos. I don't know anything about her, but she looks beautiful. She looks beautiful, but they're going to need all the help they can get when the 10 new defendants are added. So look, as I've explained to you many times, plaintiffs' attorneys are not paid by the hour. Plaintiffs' attorneys do not get paid unless they're able to win the case and unless there is a collectible settlement or judgment. So she doesn't even go here, says Kylie. She doesn't even go here. So, I mean, look, is she trying to be like the next Camille Vasquez? I don't know, maybe. She there's a similarity in look there, right? And Camille Vasquez got a huge amount of publicity by representing Johnny Depp, and this is a high-profile case, and, maybe. I think there was some press or there were some articles that she had, obtained some very big judgment of a couple $100 million or something. And so maybe she made a lot of money from that and she's doing this because she doesn't need the money, and it's high profile and she'll get publicity from it. Which brings me back to the Golden Bachelor. Who watched the Golden Bachelor the other night? Nicole admitted it. Nicole admitted that she was there because she wanted to be an influencer. She admitted it. Anybody watching the Golden Bachelor except for me? And they got it on tape. She's like, yeah, we won't, I'm here because, we won't be as big as like the Housewives or anything, but, I want to be an influencer. And then one of the women tried to tell, what's his name about it, the Golden Bachelor, and he wasn't having any of it. He's like, no, I think they're all here for the right reasons. Louise does. One person does. LL does. At least she admitted it. Right. But then somebody tried to tell Mel and Mel didn't want to believe it. And he's like, no, I think everyone's here for the right reasons. Kraken doesn't watch it, but I love your recaps. Shine on you crazy diamond that Justin was charged with drug possession was in the newspaper. Yes, we pulled that up one time a long time ago. It was in New Hampshire, right? When he was like 19 or something. So there's that. All right, I think we're going to wrap this one for now. It's Friday, so who knows what could happen later. Make sure all your notifications are set. Make sure I thought the judge already decided there was going to be one trial, Karen. I thought we went over that already. I thought we already covered that. That was this. Yeah, that was decided. That the article that you just sent me was from September 23rd. Yeah, I've already covered that. There's a whole stream on it, Karen. If you didn't see it, just go down to the Rex Sherman playlist, the Long Island Serial Killer playlist, and you can find it there. And so we did cover that when it first came out. Wait, hold on. All right, breaking on Walsh. Thank you, Kyle Sharkey. Just filed today. Defendant's motion to impound attachment. Wait, hold on. Well, a whole bunch of stuff was impounded on defendant's motion for change of venue. Why? Why would that be denied as to the motion only? The affidavit and attachments will be impounded, but the motion will not be impounded. Request for extension of commitment of a defendant for observation. The court grants the extended review period in light of the additional information provided to the court after inquiry as to how BSH, Bridgewater State Hospital, could know it needs more time after a mere 24 hours time. That said, this case is being held for trial starting on 10/2/2025. Well, of course, 10/2 has passed. I think she meant 10/20. Well, it does. We don't know because it just says 10/2. Hold on. I'm going to have to go into the court docket now. Hold on. Because I got to give you all the breaking news at the same time, right? And this is on Brian Walsh. So 1 moment. And we'll pull up the docket as we do and try and make sense of it together. It should be 10/27 or it could be 10/20, but we shouldn't have to do detective work, right? Docket should be clear. And sometimes they take a long time. Sometimes they take a long time to to scan the papers in. But here, as you can see, or maybe you can't because the font is so freaking small, it says, others request for extension of commitment of defendant for observation. So it sounds like somebody else came in and made a request to keep Brian Walsh for longer than 20 days in Bridgewater State Hospital. The court grants the extended review period in light of the additional information provided to the court after inquiry as to how Bridgewater State Hospital could know it needs more time after a mere 24 hours time. That said, this case is being held for trial starting on, it says 10/2/25. And it is requested that the staff at Bridgewater State evaluate Mr. Walsh's competency to stand trial efficiently in light of this information. As soon as the report is completed, the court shall be notified. Judge Fournier, dated today, 10/10. And then the defendant's motion to impound attachment for defendant's motion for a change of venue is denied as the motion only, but the affidavit and attachments will be impounded. Didn't we already review the motion for change of venue? Because he said there was so much publicity in Norfolk County. Let's see if any of the dates have changed. Or if they had another secret hearing today. Nope. The last hearing was the 7th. We covered that. Looks like 10/20, there's going to be, well, they still have it on for jury trial on 10/20, see? That's the date that's still here. And a conference. And then it says, but then 10/21, it's got the whole week blocked off, but then 10/27, there's going to be a competency hearing. I don't know. I don't know. I just don't know. All right, it's Friday. Anything could happen, so stay close to your phone. Make sure you have all your notifications set. Make sure you're still subscribed and you didn't get unsubscribed by accident. Not me, became a new member. Thank you so much. Welcome. And Dexter Save Us from the Commonwealth says, I tried to schedule a call with my government council rep. Once I mentioned Bev, he stopped replying. Also, today is my 27-year wedding anniversary, and you all don't know me, but donate $2.70 to Kelsey. That's awesome. Happy anniversary. Happy anniversary, Dexter Save Us from the Commonwealth. All right, so stay close to your phone in case we got to come back and cover something again later. So thank you, moderators, for keeping it classy today. There was a lot of trolls in here today. I don't know. I can't believe they waited like 12 hours to come in, but yeah, it is what it is. They like to, that's what they do. Stay cool, stay kind, stay classy. I know you can do it. Stay above the fray because I know you can do that too. All right. Peace out, my cupcakes. You want to have Paris Ray and the Crush play us out today? Hold on. I can do that for you too. What song do you want to hear? Let's see. Today is the 1010 portal. So in honor of the 1010 portal, why don't we play horoscope? Good. One of my kids is in this band, so it's the only music that I'm allowed to play without a strike. All right, go follow them on all the socials, put them on your Spotify playlist or your Apple Music playlist or wherever it is that you get your playlists from. And I might see you later. You never know. This is called Horoscopes. It's by Paris Ray and the Crush. And I think you're going to like it because I do. And, if you had a platform and your kid had a band, one of your kids anyway, you might want to promote them too, because I know you would. Love you guys. Peace.
I don't know shit about astrology, and honestly, it never bothered me until now. I'm comparing both of our horoscopes, telling my friends that it's just a joke. They know I'm down. They know I'm down. You're making me wanna call up your mama, ask you what time you were born. Tell me your star sign, baby, I swear I've never been this way before. 'Cause I'm a Virgo, Cancer rising. I guess that means that I've been doing my research, saying that we work. I've been consulting with the planets, don't totally understand it. I've manifested some kind of cosmic connection. So pull out your birth chart, my crystals are all charged. It shouldn't be that hard, written in the stars. Reading up on our compatibility, it's looking like we're lining up to be right where we should. I learned that my moon lies in Taurus. Now I don't know what that means for us, but it feels good. guess that means that I've been doing my research. Think that we might work. I've been consulting with the planets. Don't totally understand it. I'm manifesting some kind of cosmic connection. So pull out your birth chart. My crystals are all charged. It shouldn't be that hard. Written in the stars. Always used to make me laugh when you look at me like that. Written in the stars.